In the case of SAURAV Yadav versus State of UP, the Supreme Court has observed that the candidates belonging to reserved category are eligible to fill general or open category vacancies also. The bench, comprising Justices Uday Umesh Lalit, S. Ravindra Bhat and Hrishikesh Roy, held that this principle should also be followed while filing vacancies in horizontal reservations in open category. Welcome to Law Kanya. Today we will discuss the case of Saurav Yadav versus State of UP, in which Supreme Court made a landmark statement regarding reservations policy. But first, let us discuss refers to reservations enacted under Article 15 Clause 4 and Article 16 Clause 4 of the Constitution, which provide a candidate pool into the general, OBC, SC and ST categories. While this division is not stipulated by the terms of the Constitution, and the phrase backward classes or socially and educationally backward classes in addition to SCs and STs are used, it has come to incrust in both law and judicial decisions over the decades. The next term is horizontal reservations. It means reservation in favor for women, army veterans, the transgender community, although that has not happened yet, and so on. The reasons why this size of reservation is called horizontal reservation is because it cuts across vertical reservations in a manner of speaking. Imagine a graph divided into four vertical bars: general, OBC, SC, and ST, in accordance with their respective quotas. Now imagine that a horizontal bar of women that cuts across these four vertical bars, because women can belong to any of the four categories mentioned above, and the horizontal reservation in question is for women as a class. Now let us look at the facts of the case. This case pertains to selection process undertaken by the state of Uttar Pradesh to fill up 41,610 posts of police constables, including UP Civil Police, Provincial Armed Constabulary, and Fireman. In this case, Sonam Tomar and Reeta Rani, who had participated in the selection process, had approached the court with non-consideration of their claim of OBC-female and scheduled caste female candidate against the post meant for general category female candidates. It was alleged by one, a candidate from OBC category, that is Sonam Tomar, that she secured more marks than the general category woman who got her employment, and thus her applications must also be considered. Now, Supreme Court took note of several landmark judgments to come to the conclusion. The first case is of Indra Swani and others versus Union of India, which said that the horizontal reservations cut across the vertical reservations. To be more precise, let's suppose 3% of the vacancies are reserved for physically handicapped persons. This would be a reservation relatable to Clause 1 of Article 16, social reservations in favor of SC, ST and OBC under Article 16 Clause 4 are vertical reservations. Special reservations in favor of physically handicapped women under Article 15 Clause 3 are horizontal reservations. The next case is of Anil Kumar Gupta and others versus State of UP and others. This is a recent case in which a bench of two judges of court explained the concept of overall reservation as against compartmentalized reservation and detailed the steps to be undertaken while filling up the seats for vertical and horizontal reservations. If there are 200 vacancies and 15% is vertical reservation for SCs and 30% is the horizontal reservation for women, the proper description of the number of posts reserved for the SCs should be, that is, total 30 posts for scheduled caste, among which 9, or that is 30%, for women among the SCs. Now we must look at the position among different high courts on this topic. How the high courts disagree with each other. Rajasthan, Bombay, Uttarakhand and Gujarat high courts had adopted this principle while dealing with horizontal reservation. That is, these courts had held that candidates belonging to reserved categories can be considered to fill horizontal quota under the open category on their own merit. The high courts of Allahabad and Madhya Pradesh, on the contrary, held that Candidates from reserved categories can be adjusted only against their own categories under the concerned vertical reservations and not against the open or general category. Now let's look what the court said. The Supreme Court has observed that the candidates belonging to reserved category are eligible to fill general or open categories vacancies also. The bench comprised Justices Uday Lalit, Ravindra, Bhat and Hrishikesh Roy held that this principle should also be followed while filling vacancies in horizontal reservations in open category. The court has disapproved the view taken by some high courts as mentioned above at the stage of accommodating candidates for affecting horizontal reservation. The candidates from reserved categories can be adjusted only against their own categories under the concerned vertical reservations and not against the open or general category. But the bench observed that there can be special dispensation when it comes to candidates being considered against seats or quotas meant for reserved candidates, and in theory, it is possible that a more meritorious candidate coming out from open or general category may not get selected, but the converse can never be true and will be opposed to the very basic principles which will have all the while been accepted by the apex court. This was held by the bench. Thus, all the women, irrespective of whether they belong or do not belong to the reserved category, are entitled to be competent for the post marked in the favor of women under the open category. There is no reservation for post in open or general category, and horizontal reservation in favor of women in general category is available and to be filled up from amongst all women, irrespective of their caste status. This was held by the bench. Now, the bench directed in this case of SAURAV YADAV versus State of UP that all candidates belonging to OBC-female category who had secured more marks than the required cutoff, that is, the marks secured by the last candidate appointed in general female category, must be offered employment as constable in Uttar Pradesh Police. Since none of the candidates belonging to scheduled caste female category has secured more marks, the bench rejected their claim. Also, Justice S. Ravindra Bhat gave his separate judgment, agreeing with Lalit's main judgment, which later authored on behalf of the bench, and added a few more reasons of his own, which are not opposed to that of Justice Lalit. Now, he said that in 1999, the Uttar Pradesh government issued a government order providing 20% reservation on the process of direct recruitment to the state public service and posts subject to certain conditions. Now, these two are the conditions. First, if a woman is selected on the basis of merit in any state public service and post, her selection will be against the vacancy reserved for women in that category. Now, the second condition is that if a suitable woman candidate is not available for the post reserved for the women, then such a post shall be filled up from amongst a suitable male candidate, and such a post shall not be carried forward for future. Justice Bhat noted that only stipulation with respect to treatment of horizontal reservation for women is that in a case a woman candidate is selected, she would be adjusted against the appropriate social category she belongs to, that is scheduled caste, SC, OBC or the general. However, there is no rule or direction which prohibits the adjustment of socially reserved categories of women in the general category or open category. Now, he has pointed out some of the features of vertical reservations. These are: the first, they cannot be filled by the open category or categories of candidates other than those specified and have to be filled by candidates of the concerned social category only. Second, mobility or the migration from the reserved or specific category to the unreserved or open category slot is possible based on meritorious performance. Third, in case of migration from reserved to open category, the vacancy in the reserved category should be filled by another person from the same specified category lower in the rank. And the last, if the vacancies cannot be filled by the specified categories due to shortfall of candidates, the vacancies are to be carried forward or dealt with appropriately by the rules. He also made some remark on the horizontal reservations, that they are by their nature not inviolate pools or carved in stone. They are premised on their overlaps and are interlocking reservations. They cannot be carried forward. It was all about this case. If you like this video, don't forget to hit the like button. Also, let me know in the comment section as to which cases I should discuss for you all. Thank you for watching this video. See you in the next video.